If you are renting in Canada right now, and you heard about what UK renters just received in law, you need to watch this entire video today. Because what the United Kingdom did for its 11 million renters on the 1st of May 2026 is something Canada has never done, and still has not done. Today we are going to compare the UK Renters' Rights Act 2025 with what Canadian renters actually have right now across 10 provinces and 3 territories. And by the time this video ends, you will understand exactly why Canadian renters are in a fundamentally different and more vulnerable position than UK renters are today. Let us start with a fact that sets the entire comparison up perfectly, and that fact is this: there is no federal tenant protection law in Canada whatsoever right now. Not one single piece of federal legislation that protects the 4.4 million renting households across Canada from unfair eviction, excessive rent, or landlord misconduct. Housing is a provincial matter under Canada's Constitution Act of 1867, meaning every single province and territory makes its own separate rules for renters independently. This means a renter in Alberta has almost no rent protection at all, while a renter in Ontario has considerably more, and a renter in Quebec has an entirely different system. The result is a fragmented patchwork of protections that varies so dramatically from province to province that the words Canadian tenant rights barely mean anything without a province attached. Contrast this with the United Kingdom, where the Renters' Rights Act 2025 created a single unified set of protections covering all 11 million private renters across England simultaneously. One law, one standard, 11 million renters protected by exactly the same rights regardless of which city they rent in or which landlord they happen to be renting from. Now let us go through the specific protections in the UK Renters' Rights Act and compare each one directly to what Canadian renters have or do not have in their provinces. The first and most significant UK protection is the complete abolition of Section 21 no-fault evictions effective from the 1st of May 2026 across all of England. Before this date, a UK landlord could hand a tenant a notice to leave with just 2 months' warning, and without giving any reason whatsoever for the eviction. From the 1st of May 2026, that is completely and permanently gone. A UK landlord must now prove a specific legal reason before a court to remove any tenant from their home. Now let us look at Canada. Can Canadian landlords evict tenants without a legally proven reason? The answer depends entirely on which province the renter is living in right now. In Ontario, landlords can evict tenants for personal use of the property, major renovations, or sale of the unit, all without the tenant having done anything wrong at all. This is effectively Canada's equivalent of no-fault eviction, and it remains completely legal in Ontario despite enormous pressure from tenant advocates and housing organizations nationally. In British Columbia, similar no-fault eviction grounds exist for landlord use, sale, and renovations, leaving BC renters vulnerable to losing their homes without any personal fault. In Alberta, which has no rent control at all, landlords have even broader flexibility, with evictions for personal use and demolition available with as little as 3 months' notice. Nova Scotia allows landlords to evict with reasonable notice for personal use, sale, and major repairs, making Nova Scotia one of Canada's least protected rental provinces for renters. The UK abolished all of these no-fault eviction routes in one sweeping piece of legislation, while Canada's provinces still permit them in various forms across the entire country. Now let us compare the second major UK protection, the abolition of fixed-term tenancies and their replacement with rolling periodic tenancies with no end date. From the 1st of May 2026, all tenancies in England automatically converted to rolling agreements with no fixed end date, meaning tenants cannot be removed simply because a contract expired. In Canada, fixed-term leases are still the standard across most provinces, and when a fixed-term lease expires, the situation varies significantly and sometimes dangerously between provinces. In Ontario, a fixed-term lease typically converts to a month-to-month tenancy automatically, providing some protection, but landlords can still pursue no-fault grounds during that period. In Alberta, when a fixed-term lease expires, the landlord has more flexibility about whether to renew or not, leaving tenants in a position of uncertainty at every contract renewal point. In British Columbia, fixed-term leases can include vacate clauses that require the tenant to leave when the term ends, a practice that the UK permanently banned on the 1st of May 2026. The UK's elimination of fixed-term tenancies and vacate clauses represents a fundamental shift in housing security that no Canadian province has yet implemented or seriously proposed legislatively. Now let us look at rent increases, because this is where some Canadian provinces do better than others, but none quite match what the UK Renters' Rights Act now provides. In the UK, from the 1st of May 2026, landlords can only raise rent once per year using the official Form 4A, with at least 2 months written notice required before the increase. If a UK tenant believes the increase is above the local market rate, they can challenge it at a completely free independent tribunal where 71% of challengers win. In Ontario, the rent increase guideline for 2027 has been set at 1.9%, and most tenants cannot have their rent raised above this government-set annual figure. However, Ontario's rent control has a critical gap. It does not apply to units first occupied after November 15, 2018, leaving a very large portion of newer rental stock unprotected. This means a renter in a newer Ontario building can receive virtually unlimited rent increases with proper notice, a vulnerability that the UK Renters' Rights Act does not permit anywhere. In British Columbia, the 2025 rent increase limit was set at 2.3% for most residential tenancies, providing meaningful, but not comprehensive protection for BC renters. In Alberta, there is absolutely no rent cap whatsoever. A landlord in Alberta can raise rent to any amount they choose, as long as they provide 3 months written notice first. In Nova Scotia, landlords may raise rents to any amount with reasonable notice in 2026, making it one of the least rent-protected provinces in the entire country for renters. In Quebec, rent increases are regulated, but not capped by a fixed percentage. Increases are assessed based on a 4-factor method, and tenants can contest them through the Tribunal Administratif du Logement. The UK system provides one unified national standard for rent increases with a free tribunal for all renters, while Canada's approach varies from strong protection in some provinces to none in others. Now let us compare deposit rules, because this is another area where UK renters now have clearer and stronger protection than many of their Canadian counterparts currently receive. In the UK, following the Tenant Fees Act 2019, the maximum deposit is 5 weeks' rent. It must be protected in a government-approved scheme within 30 days, and there is a free dispute service. In Ontario, landlords can only collect a last month rent deposit. They cannot collect a separate damage deposit, and key deposits must be refundable and cannot exceed replacement cost. In British Columbia, landlords can collect a security deposit of up to half a month rent and a pet damage deposit of up to half a month rent for pet-owning tenants. In Alberta, security deposits are capped at 1 month rent and must be held in a trust account at a bank or credit union, with interest accruing for the tenant's benefit. In Quebec, deposits are completely banned. Landlords in Quebec cannot collect any deposit from tenants, making Quebec actually stronger than the UK on this specific issue. The deposit picture in Canada is genuinely mixed, with Quebec stronger than the UK, Ontario and Alberta comparable, and British Columbia slightly weaker than the current UK standard. Now let us look at something the UK Renters' Rights Act introduced that has no meaningful equivalent in any Canadian province: the prohibition on rental bidding wars. From the 1st of May 2026, UK landlords must advertise a specific rent price and cannot accept any offer above that advertised price under any circumstances whatsoever. This ban on bidding wars was introduced because the ultra-competitive UK rental market had seen letting agents actively encouraging tenants to outbid each other and pay above asking price. In Canada, there is no equivalent ban on rental bidding in any province, and in high-demand cities like Toronto and Vancouver, bidding wars for rental properties remain completely legal. In Toronto specifically, it is common for landlords and agents to receive multiple applications and select the highest bidding tenant, a practice that is now completely banned in England. This difference is particularly significant in the context of Canada's current housing crisis, where rental markets in major cities like Toronto and Vancouver are extraordinarily competitive. Now let us compare discrimination protections, because both countries prohibit housing discrimination, but with some important differences in scope and in the specific grounds covered. In the UK, the Renters' Rights Act specifically bans landlords from refusing tenants because they receive housing benefit or have children, making no DSS policies explicitly illegal. In Canada, the Canadian Human Rights Act prohibits discrimination based on race, sex, disability, family status, and several other protected grounds in federally regulated housing situations. However, most rental housing in Canada is regulated provincially, meaning it is the provincial human rights codes rather than federal law that primarily protect Canadian renters from discrimination. Each province has its own human rights code, and most do prohibit discrimination based on source of income and family status, which covers receipt of benefits and having children. However, enforcement varies significantly between provinces, and the explicit legislative ban on no DSS policies that the UK now has is clearer and more direct than most provincial protections. Now let us talk about what is arguably the biggest structural difference between the UK and Canadian rental systems, the pet policy situation for renters in both countries. In the UK, from May 2026, renters have the right to formally request to keep a pet, and landlords must give a legitimate reason if they refuse that request in writing. In Canada, pet policies are entirely at the discretion of individual landlords in most provinces, and blanket no pets policies remain completely legal across the majority of Canadian provinces. Ontario is a notable exception where no pet clauses in leases are actually unenforceable, meaning Ontario landlords technically cannot enforce a ban on pets in residential tenancies. But even in Ontario, landlords can seek eviction if a pet causes damage or disturbs other tenants, so the practical protection is considerably weaker than the UK's formal request right. British Columbia, Alberta, and most other Canadian provinces allow landlords to include and enforce no pets clauses in their tenancy agreements without any obligation to provide reasons. Now let us look at eviction procedure and timeline comparisons, because the process of challenging an eviction is critically important for real-world tenant security in both countries. In the UK, all evictions must now go through the Section 8 court process, where the landlord must prove a specific legal ground before a judge in order to obtain possession. The tenant has the right to attend that hearing, present their case, and the court cannot grant possession unless the legal ground is properly established and proven by the landlord. In Ontario, eviction applications go through the Landlord and Tenant Board, which has faced significant backlash for lengthy delays, with some cases taking many months to be heard. The Ontario LTB backlog, which became severe during the COVID-19 pandemic, has meant that both legitimate and contested eviction cases take far longer to resolve than the system intended. British Columbia uses the Residential Tenancy Branch Dispute Resolution process, which is faster than Ontario's LTB in many cases, but still requires navigating a provincial administrative system. Alberta uses the Residential Tenancy Dispute Resolution Service, which has binding enforcement powers, but operates under Alberta's relatively landlord-friendly legislative framework for evictions. Quebec's Tribunal Administratif du Logement is often praised as one of Canada's most accessible tenant dispute bodies, handling rent increases, evictions, and repairs in a relatively timely manner. The UK's court-based eviction process, while potentially slower for landlords in some cases, provides tenants with the most legally rigorous and rights-respecting process of any comparison country. Now let us look at what is happening with Canadian housing policy in 2026, because the federal and provincial governments are responding to the housing crisis in various ways. The federal government has committed to an ambitious housing acceleration agenda, including funds to incentivize provincial governments to speed up the building of more rental housing units. However, none of these federal housing commitments include a national tenant protection framework that would create the kind of unified rights standard that the UK's Renters' Rights Act provides. Canada's housing minister has acknowledged the housing affordability crisis but has not proposed federal tenancy legislation, leaving renter protection entirely in the hands of individual provinces. Ontario passed the Protecting Tenants and Strengthening Community Housing Act in recent years, strengthening some bad faith eviction provisions and increasing penalties for landlords who misuse N112 notices. British Columbia has introduced enhanced protections against evictions and bad faith evictions in recent years, moving closer to UK-style protections but still without a comprehensive unified framework. Alberta, despite having Canada's fastest-growing rental market, has resisted rent control and maintains one of the most landlord-friendly rental frameworks in the entire country today. The contrast with the UK is stark. While Canada is making incremental provincial improvements, the UK implemented a comprehensive national overhaul in one decisive legislative moment. Now let us address the headline claim directly. Is it accurate to say that Canada has zero tenant protection, as the title of this video suggests in a simplified way? The honest answer is that zero protection is an overstatement for most provinces, but the fragmented nature of Canadian tenant rights means many renters have significantly less protection than UK renters. A renter in Ontario has meaningful but imperfect protection with rent controls, eviction procedures, and LTB access, though the no-fault eviction grounds remain a serious vulnerability. A renter in Quebec has strong protection in some areas, including no deposits and rent tribunal access, though the 2026 Duranceau reforms have created new uncertainties around relocation rights. A renter in Alberta genuinely has very limited protection, no rent control, broad eviction grounds, and a system that overwhelmingly reflects the interests of landlords over tenants. A renter in Nova Scotia is in an extremely vulnerable position with almost no rent protection and eviction grounds that leave tenants exposed to displacement with limited legal recourse. And, across the entire country, Canadian renters face something UK renters no longer face the possibility of losing their home without any personal fault through legal no-fault eviction processes. That single fact, the continued existence of no-fault evictions across Canada, represents the most fundamental difference between the two countries' approach to renter protection today. The UK Parliament looked at a rental market where millions of people lived in daily fear of arbitrary eviction and decided that fear was incompatible with a just housing system. Canada's Parliament has not yet made that decision at the federal level, and the provinces that have acted have done so only partially and inconsistently across their different jurisdictions. If you are a Canadian renter watching this video, here's what you need to do right now to protect yourself within the system that currently exists in your province today. First, look up your specific province's Residential Tenancy Act online, because your rights are entirely determined by which province you live in and what its current legislation says. Second, know your eviction grounds. Find out exactly what grounds your landlord can legally use to evict you, and make sure you understand the notice periods and challenge processes. Third, if you are in Ontario, know that you have the right to a hearing at the LTB before any eviction order is granted, and use that right by attending the hearing. Fourth, check your province's rent increase guideline for 2026. Ensure any increase you receive complies with that guideline, and challenge any non-compliant increase through your provincial tribunal. Fifth, join or connect with a local tenant organization in your city, because collective advocacy is the most effective way Canadian renters have historically improved their legal protections. Sixth, if you experience discrimination, contact your provincial human rights tribunal or commission immediately, because discrimination in housing is illegal in every Canadian province and territory. The UK did not achieve the Renters' Rights Act overnight. It was the result of decades of tenant advocacy, campaigning, and political pressure that eventually produced meaningful legislative change. Canadian renters who want the kind of protections that UK renters now have will need to organize, advocate, and demand that their provincial and federal representatives take this issue seriously. Share this video with every Canadian renter you know, because understanding the gap between what UK renters now have and what Canadian renters currently have is the first step to change. If you are a UK renter watching this, please appreciate what the Renters' Rights Act now gives you, because it represents a level of housing security that millions of renters worldwide do not yet have. Your right not to be no-fault evicted, your right to challenge any unfair rent increase at a free tribunal, and your right to a rolling tenancy with no end date are genuinely extraordinary. Use every single one of those rights actively, and know that renters in Canada, the USA, and Australia are watching the UK's experiment in comprehensive tenant protection with significant interest. If you found this comparison helpful, please like this video right now, because it helps more renters in both the UK and Canada find this important information when they need it. Subscribe to UK Housing Alert and hit the notification bell so you never miss an update on housing law, tenant rights, and renter protections that affect you wherever you are renting. We cover UK housing law, international housing comparisons, tenant rights, and benefit entitlements every single week in plain, simple English, so you always know exactly where you stand. Your housing security matters, your legal rights matter, and whether you rent in England or in Canada, you deserve to know exactly what protections you have and which ones you still need. Now, let us look at something that does not get discussed enough in these comparisons: the practical day-to-day experience of being a renter under each of these two systems. A UK renter in 2026 knows that if they pay rent on time and look after the property, they cannot be asked to leave without a legally proven reason accepted by a court of law. That knowledge changes the relationship between a renter and their home. Fundamentally, it allows people to put down roots, invest in their community, and plan for their future with confidence. A Canadian renter in Alberta or Nova Scotia knows that their landlord can decide to sell the property, move in a family member, or pursue demolition, and they will have to leave. This knowledge creates a background anxiety that shapes how Canadian renters relate to their homes, whether to invest in improving them, whether to form deep community ties, and whether to plan ahead. The psychological difference between these two lived experiences is enormous and has been documented in research showing that housing insecurity measurably increases anxiety and reduces life satisfaction. Now let us look at the numbers side by side. How much does housing cost as a proportion of income in both countries? And what does the rental market actually look like today? In the UK, the average private renter pays approximately 35% of their monthly income on rent, with London renters paying a higher average of 44% of income. In Canada, renters in Toronto and Vancouver face some of the most extreme rental affordability challenges in the world, with many paying well above 30% of income on housing. The average rent in Toronto for a one-bedroom apartment reached approximately 2,400 Canadian dollars per month in 2026, according to recent market data. The average rent in Vancouver for a one-bedroom similarly exceeded 2,300 Canadian dollars per month in 2026, making both cities among the least affordable globally. These prices exist in a market where, unlike the UK, there is no national prohibition on no-fault evictions, and significant portions of newer rental stock face no rent control protection. The combination of extreme prices, no national standard for tenant protection, and continued no-fault eviction rights creates a rental market that is arguably more precarious than the UK's. Now let us talk about one specific area where Canada is actually moving in the right direction: the growing crackdown on bad faith evictions in Ontario and British Columbia. Ontario strengthened its bad faith eviction provisions in recent years, requiring landlords to disclose past use of no-fault eviction notices when applying for new ones through the LTB. When the Ontario LTB determines that a landlord gave a notice in bad faith, they can order the landlord to pay up to 12 months' rent to the displaced tenant as compensation. British Columbia has also enhanced its anti-renoviction protections, requiring landlords to secure proper permits before evicting for renovations and paying compensation to displaced tenants. These are meaningful improvements that move Canada towards stronger tenant protection, but they remain incremental responses to specific abuses rather than the comprehensive overhaul the UK implemented. The UK approach was to eliminate the entire category of no-fault eviction rather than trying to regulate or monitor how it was used, which is a fundamentally different and more decisive approach. Canada's approach reflects the country's constitutional structure, where housing falls under provincial jurisdiction, making a national solution constitutionally and politically complicated. However, the federal government does have tools available through housing funding conditions, incentive structures, and advocacy to encourage provinces to adopt stronger tenant protections. Housing advocates in Canada are increasingly calling for the federal government to attach tenant protection conditions to housing infrastructure funding provided to provinces and municipalities. This approach would not override provincial jurisdiction but would create financial incentives for provinces to adopt minimum national standards for tenant protection, similar to how other policy areas work. Whether Canadian governments will take that step remains to be seen, but the UK's Comprehensive Renters' Rights Act has given housing advocates a powerful international example to point to. Now let us look specifically at what Canadian renters can learn from the UK's experience of implementing comprehensive tenant protection at the national level effectively. The UK experience shows that abolishing no-fault evictions does not collapse the rental market, as some landlords and their advocates predicted when the legislation was first proposed years ago. The UK rental market continues to function with landlords still able to recover their properties for legitimate reasons through the Section 8 process with a proven legal ground. This directly contradicts the argument made in Canada that stronger tenant protections would cause landlords to exit the market and worsen the housing supply situation significantly. The UK experience also shows that a unified national standard is more effective than a patchwork of provincial rules because it removes the geographic inequality that currently defines Canadian rental rights. A renter in Manchester has exactly the same rights as a renter in London. This kind of consistency and equality of protection does not exist anywhere across Canada's provincial system. Now, let us talk about the timeline. How long did it take for the UK to achieve this comprehensive level of tenant protection, and what does that tell us about the Canadian path forward? The Renters Reform Bill was first introduced in the UK in 2022 and went through extensive parliamentary debate and amendment before finally becoming the Renters' Rights Act in 2025. The process took approximately 3 years from initial introduction to final implementation, suggesting that even in a jurisdiction with political will, comprehensive reform requires sustained effort. Canada is arguably earlier in that reform journey, with the political will at the federal level being less clearly established than it was in the UK when reform became a genuine priority. The lesson for Canadian tenant advocates is that persistent, organized, evidence-based campaigning over a period of years is what turns housing reform from a policy proposal into enacted legislation. Renters in both countries who want better protections need to be engaged, vocal, organized, and politically active, because housing reform does not happen without sustained public pressure over time. The difference today is that UK renters can point to what comprehensive protection actually looks like, while Canadian renters are still making the case that it is possible and necessary. That is a powerful tool. The UK's Renters' Rights Act is now a real-world example that housing advocates in Canada, Australia, the USA, and elsewhere can point to as proof of what works. Subscribe to UK Housing Alert and hit the bell to stay updated on housing rights comparisons, UK law updates, and international rental market coverage that matters to renters everywhere. Share this video with every renter you know in both the UK and Canada, because understanding these differences is the first step toward demanding the protections that all renters deserve. UK Housing Alert is here every week, making sure every renter knows their rights and understands exactly how their housing protections compare to renters in other countries worldwide. Now let us look at Manitoba, where landlords can evict for personal use or renovation with 3 months' notice, and rent increases follow an annual guideline. Manitoba's 2026 rent increase guideline sits near 2% for most units, though landlords can apply for above-guideline increases through the residential tenancies branch in specific cases. In Saskatchewan, there is no rent control at all, and landlords can raise rent by any amount as long as they provide the required written notice. Saskatchewan tenants facing eviction for landlord use or sale have limited recourse beyond the Office of Residential Tenancies, which operates under a distinctly landlord-friendly provincial framework. New Brunswick allows landlords to evict for personal use, sale, or renovation, and its rent increase rules remain comparatively weak next to neighboring Atlantic Canada provinces. Prince Edward Island actually has one of Canada's more protective systems, requiring landlords to justify rent increases above the annual guideline before the Island Regulatory Board. Newfoundland and Labrador has no rent control whatsoever, leaving renters in St. John's exposed to unlimited increases during one of Atlantic Canada's fastest rising housing markets. In the Yukon, rent increases require proper notice but face no percentage cap, while eviction for landlord use remains legal with a relatively short notice period. The Northwest Territories and Nunavut face acute housing shortages and overcrowding, compounded by the extraordinarily high cost of building rental housing in remote northern communities. Across every territory and most provinces, the pattern remains consistent. Protections exist unevenly, rent caps are inconsistent, and no-fault eviction grounds persist almost everywhere. It is worth clarifying an important nuance here. The UK's Renters' Rights Act 2025 applies specifically to England, not to Scotland, Wales, or Northern Ireland. Scotland already abolished no-fault evictions back in 2017 under separate legislation, making Scotland the first UK nation to eliminate Section 21-style evictions entirely for renters. Wales introduced its own Renting Homes Act in 2022, requiring 6 months' notice for no-fault evictions, a reform that predates England's more recent comprehensive overhaul. Northern Ireland has been slower to reform, with campaigners there now pointing to England's Renters' Rights Act as a model for its own future legislation. This means that within the United Kingdom itself, renters already experienced a patchwork before England's reform, somewhat resembling Canada's current fragmented provincial rental landscape today. The crucial difference is direction and speed. Every UK nation has been moving steadily toward eliminating no-fault evictions, while most Canadian provinces have not. Let us talk about student renters specifically, because this group faces unique vulnerabilities in both countries that general tenant protection statistics often fail to fully capture. In the UK, the Renters' Rights Act includes specific provisions for student housing, including possession grounds tailored to purpose-built student accommodation and the academic year cycle. In Canada, international students frequently face predatory rental practices, including illegal extra fees, overcrowded housing, and landlords who exploit unfamiliarity with provincial tenancy law entirely. Ontario and British Columbia have both seen documented cases of international students paying illegal above-market rents for basement rooms with no formal tenancy agreement whatsoever. Because many international students fear jeopardizing their study permits, they are significantly less likely to report illegal landlord behavior to provincial tenancy boards or authorities. This creates a hidden layer of exploitation within the Canadian rental market that mainstream tenant protection statistics simply do not adequately reflect or capture fully. The UK's approach of embedding specific student protections directly into national legislation stands in contrast to Canada's more ad hoc, campus-by-campus approach to student housing. Now let us discuss guarantor requirements, because this is another area where practices differ significantly and Canadian renters often face additional financial hurdles as a result. In the UK, guarantor requirements are common but regulated, and the Renters' Rights Act includes provisions protecting guarantors when a tenant dies during the tenancy period. In Canada, landlords frequently require guarantors for newcomers, students, and low-income applicants, with no standardized protections for what guarantors can actually be asked to cover. Newcomers to Canada, without established credit history, often struggle to secure rental housing at all, facing discrimination that, while illegal, remains difficult to prove or prosecute. Housing advocates argue that Canada needs clearer national guidance on acceptable tenant screening practices, similar to protections the UK has built into recent legislation. Now let us talk about rent banks and emergency rental assistance, because access to help during a financial crisis varies enormously between the two countries. In the UK, discretionary housing payments through local councils can provide emergency support to renters facing shortfalls, alongside the broader universal credit housing element system. In Canada, rent banks exist in some municipalities, offering interest-free loans to prevent eviction, but coverage is patchy, and many smaller communities have no rent bank. A renter facing a temporary income shock in Toronto might access emergency funds through a rent bank, while a renter in rural Saskatchewan may have no comparable option. This uneven safety net compounds the uneven eviction protections, meaning a Canadian renter's overall vulnerability depends heavily on both their province and their specific municipality. Now let us look at legal aid access, because navigating a tenancy dispute without proper legal representation puts renters at a significant practical disadvantage in court. In the UK, Citizens Advice and dedicated housing charities provide free guidance to renters facing eviction, alongside legal aid available for the most serious housing cases. In Canada, legal aid clinics exist in most provinces, but funding cuts over the past decade have reduced capacity, leaving many tenants to represent themselves at hearings. Ontario's community legal clinics report being unable to meet demand, meaning many tenants facing eviction at the LTB attend hearings without any legal representation whatsoever. This representation gap matters enormously because tenants without legal help are statistically far less likely to successfully challenge an eviction application than those with representation. The UK's more accessible legal support network, combined with the free rent tribunal system, gives renters there a meaningfully stronger practical position when disputes eventually arise. Now let us examine tenant unions and organizing, because collective action has historically been one of the most effective drivers of housing reform in both countries. The UK has a long history of tenant unions, with organizations like Acorn and Generation Rent playing a documented role in building pressure for the Renters' Rights Act. In Canada, tenant unions have grown significantly in recent years, with groups in Toronto, Montreal, and Vancouver organizing rent strikes and building specific tenant associations locally. The Parkdale Community Legal Services and similar organizations in Toronto have supported tenants in significant rent strikes against corporate landlords over above guideline increase applications. Quebec has one of Canada's strongest tenant organizing traditions, with groups like the Regroupement des Commerces Logement actively shaping provincial tenancy policy for decades now. These organizing efforts matter because the UK's own Renters' Rights Act emerged only after years of sustained pressure from similarly organized tenant advocacy groups nationally. Now, let us discuss cooperative and social housing, because this sector operates under different rules than private rental in both the UK and Canada today. In the UK, social housing tenants have long enjoyed stronger security of tenure than private renters, though waiting lists for social housing remain extremely long nationally. In Canada, cooperative housing offers strong tenant security through member governance, but co-op housing represents a small fraction of the overall national rental stock. Federal investment in non-market and cooperative housing has increased somewhat in recent years, though advocates argue the scale remains far below actual documented need nationally. The comparative security of co-op and social housing in both countries suggests that ownership structure, not just legislation, plays a meaningful role in tenant protection. Now let us return to the private rental sector and discuss how landlord licensing schemes differ between the UK and Canadian jurisdictions right now today. Many English local councils operate selective licensing schemes requiring private landlords to register and meet property standards before legally renting out their properties to tenants. In Canada, landlord licensing exists only in a small number of municipalities, with most provinces having no requirement for landlords to register their rental properties at all. Toronto operates a limited rental licensing program for certain property types, but enforcement capacity remains constrained relative to the scale of the private rental market. This licensing gap means many Canadian tenants have no straightforward way to verify whether their landlord operates legally or has a history of tenancy violations. The UK's more developed licensing infrastructure, while imperfect, provides local authorities with an additional enforcement tool that most Canadian municipalities currently lack entirely today. Now, let us look at property condition and repair standards, because a right to a habitable home means little without an enforceable mechanism behind it legally. In the UK, the Decent Home Standard is being extended to the private rental sector, requiring landlords to meet minimum condition standards or face enforcement action. In Canada, provincial standards vary, with Ontario requiring landlords to maintain properties in a good state of repair, enforceable through the Landlord and Tenant Board. However, enforcement in Canada often requires the tenant to initiate a complaint, whereas the UK's approach places more proactive inspection responsibility on local authorities directly. Renters in poor condition housing across Canada frequently report mold, pest infestations, and inadequate heating with limited practical recourse beyond lengthy tribunal application processes overall. This practical enforcement gap means that even where Canadian tenancy law technically requires repairs, the burden of pursuing action falls disproportionately on individual tenants themselves. Now let us talk about something increasingly relevant: short-term rental platforms and how they affect long-term rental availability in both countries today directly. In the UK, new registration requirements for short-term letting properties aim to track how many homes are being diverted from long-term rental into platforms like Airbnb. In Canada, cities including Toronto, Vancouver, and Montreal have introduced short-term rental restrictions, requiring hosts to rent only their principal residence to reduce housing diversion. Studies in both countries suggest that short-term rental conversion has measurably reduced available long-term rental stock in high-tourism cities, worsening affordability for local renters. Enforcement of short-term rental rules remains inconsistent in Canada, with many municipalities lacking the resources to identify and penalize properties operating in violation of bylaws. This regulatory gap compounds existing affordability pressures, particularly in cities like Vancouver, where short-term rental conversion has been repeatedly identified as a contributing housing factor. Now let us look at climate and energy efficiency requirements, because rental housing quality increasingly includes environmental performance standards in modern tenancy legislation today. The UK is moving toward requiring private rental properties to meet minimum energy efficiency ratings, reducing tenant heating costs and improving overall housing quality standards nationally. In Canada, energy efficiency requirements for rental properties are far less developed, with most provinces having no minimum energy performance standard for rental units at all. This matters directly for renters, because poorly insulated rental units mean significantly higher heating bills, particularly during Canada's harsh winter months in northern regions. Some Canadian municipalities have introduced voluntary retrofit incentive programs, but mandatory minimum standards for rental energy efficiency remain largely absent from provincial tenancy legislation today. The UK's approach of embedding energy standards into tenant protection legislation reflects a broader recognition that housing quality includes environmental performance, not just basic habitability. Now let us discuss something that affects renters directly: how eviction data and reporting transparency compare between the United Kingdom and Canada currently today. The UK government publishes detailed quarterly eviction statistics, including grounds used, court outcomes, and regional breakdowns, giving researchers and advocates clear visibility into system performance. In Canada, eviction data reporting varies enormously by province, with some tenancy boards publishing detailed statistics and others providing minimal or delayed public reporting overall. Ontario's Landlord and Tenant Board has faced criticism for insufficient data transparency, making it difficult for researchers to fully assess the true scale of evictions. This transparency gap matters because without reliable data, it becomes considerably harder for Canadian advocates to build the evidence-based case that helped drive UK reform. Better data collection and public reporting could strengthen the case for Canadian tenant protection reform by clearly demonstrating the true scale of the problem nationally. Now, let us look ahead at what upcoming provincial elections could mean for tenant protection reform across several Canadian provinces in the coming years ahead. Ontario, British Columbia, and Quebec have all seen tenant protection emerge as a genuine electoral issue, with housing affordability consistently ranking among voters' top concerns. Whether any provincial government moves toward comprehensive reform similar to the UK's approach will likely depend heavily on sustained public pressure and electoral consequences. Federal party platforms have increasingly referenced housing affordability, though comprehensive national tenant protection legislation has not yet appeared as a concrete federal policy commitment. Housing advocates continue pushing for the federal government to use funding conditions as leverage, encouraging provinces to adopt baseline tenant protection standards nationally today. Whether this strategy succeeds may determine whether Canada moves toward a more unified system or remains a patchwork of dramatically inconsistent provincial protections indefinitely. Now let us summarize the single biggest practical takeaway for Canadian renters watching this comparison and wondering what it actually means for their situation. Your specific rights depend entirely on your province, so the very first step toward protecting yourself is understanding exactly what your Provincial Tenancy Act actually says. Do not assume that, because a neighboring province offers strong protection, your own province offers anything similar, because the differences between provinces are often substantial. If you are unsure of your rights, contact your provincial tenancy board directly or reach out to a local tenant organization for accurate, up-to-date guidance. For UK renters, the biggest takeaway is different. You now have some of the strongest tenant protections in the world, so understand and use them fully. Know your Form 4A rights, know your free tribunal access, and know that no-fault eviction is no longer something you need to fear under current law. Both UK and Canadian renters share something important, and common protections only matter in practice when renters actually know about them and use them. Legislation alone does not protect anyone automatically. It requires renters to understand their rights, document their tenancies properly, and act when those rights are violated. This is exactly why comparisons like this one matter, because understanding what is possible elsewhere helps renters everywhere push for stronger protections back home too. If this video helped clarify where you stand as a renter, consider sharing it with someone who is currently navigating a difficult landlord situation right now. Comment below and tell us which province or country you are renting in, because we read every comment and it helps shape our future coverage. We will continue tracking how the UK's Renters' Rights Act performs in practice, and whether Canadian provinces begin moving toward similar comprehensive tenant protections nationally. Housing security should not depend on geography, yet today it clearly does, and closing that gap will require sustained pressure from renters in every province. Thank you for watching this comparison to the end, and remember, UK Housing Alert will keep bringing you the housing law updates that matter.